Josh, I want to go to you, and I want to ask you about what we hear that the defendant intends to take the stand in his own defense. You're a defense attorney. What do you think, strategy-wise? You think that's going to be a good move? Of course, it's his choice. If the defendant wants to take the stand, that's his constitutional right. And no matter what you say as a defense attorney, if that's what they wanted to do, that's what they're going to do. But what do you think? You think it's a good move?
You're right. As a defense attorney, you're always terrified when your client says to you, "I want to take the stand," because you don't know what's going to come out of their mouth. You don't know what they're going to be asked on cross. It's when the trial is no longer in your control, and there you've got your client vulnerable, sitting there on the stand, being grilled by a prosecutor. But in this case, it might be different because folks need to understand why he made the decisions that he made that day. This is coming down to him firing his weapon in a reckless way into an apartment building that may have endangered others. And it's true. It's not connected to the death of Taylor, and so that will be something that obviously the lawyers are going to have to deal with. But he's going to really need to explain why he pulled that weapon, and maybe he's the only one who's best suited to do it. Maybe there are not other witnesses who were around him when the shooting took place, and it might help the jurors to understand the stress, the fog of war, as it were, that he was dealing with, and why it was that he pulled his weapon and fired in the way that he did. Because otherwise, we're left with evidence that just appears to be very damning to him.